Thank you very much, Mr. Chair, and I want to thank the witnesses for coming today. It's always a real treat to have the depth of legal knowledge that we have when the group of you come to this committee. So I want to start by just framing the questions that I'm going to ask. So since Bill C-75, the principle of restraint really has become the dominant lens through which bail decisions are made. And while the criminal code has always permitted detention on public safety and confidence grounds, the statutory emphasis on restraint has really shifted judicial culture towards release as the default outcome over the last number of years, particularly in Crown onus cases. And I think what we see with C-14 is the government has admitted that that approach just really isn't working. But at the same time, while C-14 attempts to recalibrate the culture by stating that restraint doesn't require release, it leaves Section 493(1) intact and unaltered, which means that it still prioritizes from a legislative perspective, or appears to prioritize from a legislative perspective, release first and conditions second. And so, given that judges already have clear authority under Section 515(10) to detain, and that this legal authority sort of already exists, I'm wondering if you could talk a little bit about what concrete changes we can expect to see in day-to-day bail outcomes in terms of what Canadians can expect from the bill.
Thank you for the question. So I think one of the changes that is fairly new in terms of the criminal code is that the bail provisions will make clear that the principle that release ought to be the starting point at bail won't actually apply in a reverse onus situation. So this proposal really has the objective of reinforcing the presumption of detention in reverse onus hearings and trying to give a bit more teeth to the reverse onus bail hearing. In addition, there's a proposal in Bill C-14 that would make clear that the latter principle doesn't apply to people in a reverse onus situation, and it will clarify the burden of the accused at the reverse onus hearing. So I think
ask a little bit about what the practical. You're still talking about the theory. I want to know what practical difference it is. I asked the minister what category of offender will now be detained that wouldn't have been detained under existing law. I want to know how this is actually going to change things. What will defense counsel have to do differently? Who will stay in jail that wouldn't be in jail now? Can you give us some concrete examples?
Sure. So no one can automatically be denied bail, and we can't guarantee that certain provisions are going to result in the detention of anyone, because judges will always have discretion at the bail stage of proceedings to be consistent with the Charter.
That 493(1) is still in place, and so it's still the basis of their decision making. Is that what is new? What is different? What is going to change?
The objective is to ensure that there's more scrutiny given to bail release plans, particularly for people who are in a reverse onus, and that stronger bail plans will have to go before the court in a reverse onus hearing before someone's released on bail.
So it's marginal?
I wouldn't say marginal, no.
Well, what makes it not? I mean, this is the bail plans are already supposed to be there. This is the job of counsel. I mean, it sounds like what you're saying is counsel will have to do a better job. What is going to be different?
I think the hope is that more scrutiny will be given to bail decisions, and that more information will also be before the court. There are a number of amendments in the bill that will ensure that the court has more information. You have to remember that bail hearings often happen within 24 to 48 hours after someone's arrested, and so there is limited information. But I think what the code can do is it can draw courts' attention to certain risk factors that are important to consider.
With all due respect, hope not being a strategy, hope is not a strategy, which is what you started the last answer with. And we are in exigent situations, 24 to 48 hours. What new information is there? What is going to change? Like, I'm really genuinely interested in knowing what will be different other than more paperwork.
I'm not sure there'll be more paperwork. I think, as I said, there's going to be more pressure.
Stronger bail plan is presumably more paperwork. What is genuinely, what is other than signaling some hope and some hope that things are going to change, what new tools do judges have? What tools have been taken away in the context of the underlying provision not changing?
So there's also going to be an expansion of the grounds for detention, which is quite significant. The tertiary ground will be expanded so that courts are looking at outstanding charges and determining whether confidence in the administration of justice will be undermined. I think historically courts tend to focus on, like, they're looking at, is there a pattern of behavior? They're looking at, are there past convictions? But what we've heard and what the minister has heard also is that there are concerns that people are being released and then they're caught again and then they're back in the system. And so ensuring that courts are taking into account factors such as outstanding charges, I think the government thinks would make a difference in this bill. So expanding the tertiary ground is one way that this bill would do that.
Thank you. Ms.